When negotiating design and construction contracts, one of the first issues to arise is whether you are going to propose a form of your own creation as the basis for contract negotiations, or whether you're going to be providing comments in response to a contract form that somebody sends to you. Now, I'm perfectly willing to use either my own forms or somebody else's forms because it really is just a starting point for negotiation. And I think with my experience, when I receive a deficient contract proposal, I can generally fix it, I can clean it up. But all things being equal, I prefer to use a form that I prepare for my clients as a basis for negotiations. And that's not because I'm trying to seek an unfair advantage. I believe that design and construction contracts should be commercially reasonable and reasonably complete, and that's what I strive for my forms to be. What I dislike is when I'm asked to provide comments in response to a contract that is either incomplete, missing enormous sections of text to address important issues that might arise in the project, or when I receive a contract that's unfairly one-sided in the other party's favor. Because people tend to fall in love with their own contract forms and may define a win in contract negotiations as accepting the fewest changes possible. In my opinion, all architects, engineers, contractors, developers, and owners should have their own thoughtful suite of design and construction contracts. In a perfect world, they'll get to use those contract forms as a basis for negotiations. But even if they're responding to somebody else's contract form, it can help for those parties to have an understanding of what sort of terms they like to have in their contracts so that they can thoughtfully respond.